This presentation is set to really the audience of the professional, client, and those with supporting clients. But what we'll do is to just explore through where mediation fits within all of that, really. So let's just get the slides open. Okay, so the title is, of course, is mediation right for my client? Now, part of IMAL is we should be saying, yes, it is for everything. Of course, we should be. But there are some instances where it's not necessarily the right thing to do. And there are some things we need to think about if we're talking to our clients or people about mediation, or even as a mediator, looking at and explaining to potential clients whether it is something which is suitable for their particular dispute. Today, we're going to go through a few things, such as the people involved, the problems that they encounter, potential solutions, some limiting factors, and where mediation fits, whether it's part of the solution or range of options or as the actual solution itself. This chap here, Paul Randolph, had the privilege to know him before he passed away. Absolutely instrumental, especially in the UK, in terms of mediation training, development, and knowledge. And I have a copy of his book, love it, read it cover to cover, exceptionally clever chap. But this here is really looking at, why people do things that they do and act in particular ways. So his quote from his book is, "All those with the task of managing and resolving disputes will at some point find themselves asking the same rhetorical questions, i.e., why do these people act irrationally? Why do commercial business people have so uncommercial and childlike manners and behaviours? And what is it that so quickly drives people into these disputes in the first place? Why can't you just sort it out?" To wring their necks sometimes. But there's a reason. And it's all about this existential thinking. And that's, for those that don't understand what that is really, in a nutshell, looking at people having free will to do things they want to do, and being responsible for their own actions. And it kind of determines what it is you do and how you respond to things. There's a big whole lot of philosophy behind it, and Paul goes into that in his book. So from that, we can see some things. So there are some different mindset types, and there are 5 key mindset types. There are those who are absolutely uber positive, nothing's a problem, everything's possible. There's never going to be any doubt in anyone's mind that something can be achieved. We all know 1 or 2 of those. Then the polar opposite to that is those that are uber negative. Nothing's going to be able to be achieved. There are problems in every situation. You're going to have to do a lot of convincing for that person to be able to move forward in any way, shape or form. There are some people in the third sector who are detail driven. So they're not necessarily negative or positive per se, but they need to understand the details. They have to know what is going on and the whys. Remember the why child at school? These sort of people. So really asking all the questions. I will make a decision when I understand all of the information that's being put before me. And then there are the overthinkers. Now, could be a combination of 1 to 3, to be fair, but the overthinkers may flippantly agree to something and then redigest that information and process and worry and overanalyze what's going on. So you need to cater for these kinds of people. And of course, number 5, nonchalant people really don't really understand whether there's a problem to anything or not. They're very happy-go-lucky, but don't give much thought to much of the detail or situations that they come across. Why is this important? Especially in dispute resolution, mediation being part of the toolkit. It's really important when you're thinking about your client, because when you enter a conversation about options of how to resolve something or moving forward with something, your phraseology on how you address particular things and give them that information will need to be adapted. You'll need to understand whether somebody needs a lot more information or less of that information, whether somebody will be readily, easily convinced of something that's positive that will happen, or whether actually they need to be convinced because they don't think positively. So having a think about that before you give somebody that advice and guidance will allow you to frame how you talk to that person, but also think about the options. So if someone goes into mediation as one of those ways forward, as a very negative person in a very negative mindset, it's unlikely to result in anything substantively positive at all. Of course, part of the beauty of a mediator's toolkit themselves is to really work with those individuals, understanding these mindsets and bringing the conversation forward and overcoming barriers. But before you get to that stage, is it something that your client is going to be receptive to, or do they in fact need to consider other options? If they are not yet receptive to mediation, then potentially, depending on the mindset, potentially, of course, they may need different information to allow them to decide whether mediation or any other option is relevant for them. Moving from people to problems, your client or clients are faced with a range of complex or not so complex problems, and arguably what's put in front of you is very emotional in many circumstances. But fundamentally, there are 4 key foundations for problems in life, generally, per se. Everything can really be led back to these 4 things. It's something about money. You owe somebody some money, or you want compensation for something, and that's monetary led. People, you fall out with somebody or other people, and whether that's because of misunderstanding or miscommunication or some other external factors that bring those people together, it's a relationship thing which needs to be worked on. The law sets in black and white, and often very grey, lots of rules and procedures which you must adhere to, or things you must not do, but they present themselves lots of different issues, and interpreting the law, for example, is a great area for us to get stuck into, and problems can be created as a result of that. But when individuals know a little bit about the law and they are unhappy with the other person not adhering to those laws, that's when problems will arise, and that is another fundamental foundation. Aside from the law, I'm making this a distinction here, rules and procedures, and we're talking really about potentially corporate documentation or soft legislation, and areas of management which govern how people behave in certain situations. They're not necessarily the law itself, but they are localized regulations and procedural things that we have to adhere to. And if you look at all the things that your clients are going through, you can normally pinpoint, trace all the way back to at least one of these particular areas, probably multiple here. But if you look at these key problems, that's kind of a stepping stone to looking at potential solutions for these, for your clients. So the traditional solutions matrix in litigious, certainly contentious things, matters, again, line up with what the problems are. So very fixed in what we can do necessarily, and the outcomes will either be something about money, so the outcome will be party A will pay party B a sum of money, either that is a refund or compensation or whatever that may be, or future financial benefit. People-centric, so we're going to either fix, create a relationship, or sometimes end particular relationships, stop something from happening, whether it's through a contractual legal thing, or it could be because of a family relationship thing. The law itself comes into play here. So the law will dictate on most occasions what an outcome may be, and then it's advising on what those outcomes or procedures and sort of ways forward may be entered into. But of course, beyond the initial solution for the people in front of you, does that then lead to a change in the law? Does it mean that actually there's a wider impact here to consider? So some things that are solution-based, although they fix temporarily something for the people in front of you, we may need to consider, we'll talk about this later, the implications of the pieces. And then on a similar basis, you've got rules and procedures, as we spoke about, internal, policies and HR documentation, which say, if in this situation, this is the way the company perceives how to deal with something, and it may seem unfair, and as a result of an outcome, as part of an internal process, you can decide what you do about that and how you interpret something. But the wider impact of that is that maybe the business needs to reflect what that documentation is, and it may be that actually, it doesn't fit then following that outcome. If, for example, you're advising your client as to what you want to enter into, you need to be aware of these things, what exists in terms of, and we'll talk about this later, but limiting factors. What is it that you can and can't do to resolve something? So these traditional solutions, therefore, align with contentious issues going to court, litigation, arbitration, internal procedures such as disciplinary, hearings and tribunals and all of that, okay? And they're rigid, they're fairly rigid solutions. Then we look at mediation. We'll bring mediation into this because mediation is, as we know, a very flexible way of resolving a problem in front of us. So we can, between the parties, decide anything we want effectively. Yeah, so you can say, well, I want out of this and we're going to pay or do or amend this in this situation. Great, fine. And that allows you to really be very creative. And so if you're advising your clients about what they want, if they are thinking outside the box, or they could potentially think outside the box and make it fit. One of the webinars we dealt with earlier in the week, yesterday, Thursday, was about international trade. And one of the mediators referenced a very creative commercial outcome, which the court could not decide because the contract was black and white. If a party loses, this is what you pay. If a party wins, that's what you get. But the parties can sit back and reflect on what's good for them, and whatever situation it's in. And it can actually be an international, global or multinational problem with worth millions or billions, or it can be a localized family situation, and where intergenerations talk about the care of their grandfather, grandparents, somebody, and everything in between. Because you have that ability to be creative, it's such an empowering position to be in. So you are in complete control over what it is you want to agree between you. There's a fine line, therefore, between what you can do locally for you and having the authority to make a decision on a wider impact basis. So you'll hear this word authority being brought up. Do they have the authority to make a decision? And that authority is relative to what it is that the parties in front of you as a mediator or professional client, but also what decisions they're making for and on behalf of themselves or other people. We have had experiences of dealing with block management. So you have companies limited, created to manage leasehold block, for example. So you don't want 20 people turning up at a mediation to fight over what they all think may or may not be the solution. That's not really going to be successful. But you want people to represent those other leaseholders and come forward and have a sort of a generalized, harmonized way of agreeing something. So you have representatives. Do they have the authority to agree all the things through mediation, and without documentation behind that to back it up from 20 or 19 other residents? No, they don't necessarily have the authority. So as a mediator, you've got to understand where that chain ends, the golden thread to the end of the decision. And they may need to gain authority to make a decision on the day. So nobody should be entering into mediation unless you can decide something for and on your behalf, or for and on behalf of other people. And that could be in a capacity as a lawyer, could be in a capacity as you as a leaseholder, property management owner, company, could be in your capacity as an HR manager, for example, or business representative in terms of a contractual dispute. So empowerment is very important, but authority to decide something is equally as important. So you can be empowered to make a decision, but you have to have authority to do so. And then the final point here, mediation is very powerful for, I would say, 99% of any conflict or disputes. It can work without question. However, the 1% I'm going to allude to are where, and as a professional advisor, you need to think about, well, yes, the parties can decide something and we think this is going to work for them. Do we need a third party decision decided by a third party professional? So is it an arbitrator that needs to get involved? Do we need expert determination to make a decision on a problem or range of issues? Does the law dictate that we need to follow a particular process, or the contract dictate the same? So where mediation dovetails in is understanding what those limitations are and what you can enter into. There's some work behind the scenes trying to encourage businesses to amend their dispute resolution procedures internally, so there is mediation dovetailed in, because ordinarily if you pick up a contract, commercial contract, ordinarily the ADR provisions say, well, we're either going to allude to and utilize arbitration or straight to litigation, or we're going to do X, Y, and Z. Very few of those mention mediation as part of that process. And the same thing is true for grievance procedures, disciplinary procedures, and actually thinking very clearly about as a professional advisor what those limitations are. You need to think and look back at that documentation. What are the things that we need to consider, and where does mediation fit? However, if all of that lines up really well, then for the 99% of the conflict that you've got, mediation tends to be the ideal solution. We have alluded to limiting factors. Limiting factors are time. Have you got time to enter into the negotiation? You may be bound by a legal process, for example. Time may not be on your side. You may have a very short window with which to discuss something. If it is, can you do something about it? Can you amend that time structure? Do you need to make an appeal to the court, for example? Do you need to hold application in there? Or is time not an issue? Does your client have no boundaries in terms of time? Money. Principles are important. Money is important if you're going to enter any procedure to resolve something. You're going to have to put your hand in your pocket and pay for something to be done. Pay for professional advice, guidance, and support. You as a professional advisor then understand what your client's budgets are. You as an individual know what your budget is. Are your pockets deep? Do you not really care about how much money you spend on something? Is it the principle of the matter? If your budget is tighter, does that make a decision, difference for you? Is your decision process as to where you go with something? Not to say that mediation is per se cheaper as a whole process, because, and there is some thought process about that, but if you're still involving lawyers and other professionals to be part of the mediation thing, it's still going to cost you a similar amount of money for that. What's going to change is that the legal fees and supporting the legal process will be greatly reduced. You still want a mediator, and they're going to be, the best ones are, you can spend a lot of money, but you want the best. You want the people to help you, and the time factor is shortened down. So where you're actually spending good quality money on value added services, mediation will come to its fore, because you've got somebody who can help you get over those problems and hurdles and barriers in a much shorter space of time. Other limiting factors, we've talked about the law and regulation and rules and procedures. That's where they come in. You need to be alert to these other limiting factors and understand whether some other process must be taken to resolve a particular matter in front of you. Thinking about mediation in two ways now. Mediation can be a standalone service. It can be something as a professional you think, okay, the best way to resolve this is mediation, fine. But also, it could form part of your overall strategy for getting resolution. You may think, and you may agree with your clients, that, you know, a final decision is needed, or some other thing needs to be engaged with. But if you look at mediation as a very good way of moving things forward, you may be able to understand better what the issues are. You may be able to deal with some of those concerns and issues. It's a good way of exploring and opening conversations between the participants or the legal professionals involved. Because it's not a legal process, it allows you, and the mediator's role, if you like, is to allow you to open up your mind to coming to a different way of thinking, so creative thinking about solutions. So a mediator will be able to sit there and poke and prod a bit, make you feel a bit uncomfortable at stages, but allow you to go through that internal process of working out, well, what actually is best for me? Do I just want to have the judge say yes or no, and I just want to pay several £1,000s to get this resolved? Or do I actually want something commercially to work for me? Or in an employment setting, do I actually want this relationship to be better and actually not have this problem again? So it allows you to think creatively. So therefore, it can be very supportive of these ordinarily, you know, rigid processes, such as litigation, disciplinaries, arbitration, investigation as well, insurance investigations, we're talking about here, opening up and exploring those avenues, where there have been personal injury problems as well, and understanding, and some people just want an apology. There's a lot of work going on in that sphere as well, and with peer mediation in schools and colleges and educational institutions. And if you think of a process, any process in any sector, any form of life, mediation, and the principles behind it can be invaluable to that. And of course, as the solution to a problem, mediation, for those that aren't aware, requires all party involvement. So everyone's got to come to the table. They've got to agree to the process. It's not like law, litigation, court, where you can be pulled into a process whether you want to or not. It's a voluntary process, so all of you have to be engaged with it, and you have to act in good faith. And that means not just ticking a box, not just being playing lip service to a process. It's really thinking about, I want to move forward, and whatever that looks like, I don't know. That's for you to decide. But it means that having open conversations about what isn't working and what is working and how we can move forward. And as I've alluded to before, it's having the authority to make the right decisions as part of this process. But the job of the mediator, the role of the mediator, is to allow you to move forward, whatever way that is and however that works out. So understand how mediation works in the first place. And that's different. Again, different sectors, different mediations have different styles. And actually your situation may require a different approach entirely. We've now got lockdown. This is when this is being recorded. So actually now pretty much everything is being done by Zoom or other similar platforms. So remote online mediations. So actually thinking about how this works for you, this could be a very new opportunity. You may not have come across mediation before, so they will help you with that. But it's really important to know that you can vent and share confidentially the things that are worrying you with your mediator. So they will listen to you, they will help you navigate through what those issues are, and be that person, that set of ears for you to allow you to get off your chest something that's worrying you. And through that initial process, you'll start thinking positively about what you can do moving forward. And the together bit and the shuffling process through mediation allows you both to, as I've referred to before, the tango of mediation. Really, it's about working together with your opposition to enable you to come to a conclusion together, because you have to work together whether you like it or not, because if you're going to agree something, that's the important bit. So actually respect comes out of this process. A better understanding of the other people involved comes out of the process. And when you start thinking along those lines, then you're more amenable to finding those solutions together.